Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're talking about the limits on police searches and a new case heading to the Supreme Court of Canada. The case involves a vehicle that was parked on a private driveway while running. Calls had been made about a suspected impaired driver in a vehicle matching its description, but when police found the car on the private driveway, could they enter the property to investigate? In this case, R and Singer, they did. They entered the property, peered into the car windows, opened the door, and woke up a man who was inside and charged him with impaired driving. Now, impaired driving is a serious social ill and a criminal offense. But could the police enter his property and search his car without a warrant? The Crown has claimed they have an implied license to enter property to communicate with the property owner. But in this case, they did more than communicate, they collected evidence. Can that evidence be used to charge this man, Singer, with a crime? That's what the Supreme Court will be considering in this case originating from Saskatchewan. And the charity that I work for, the Canadian Constitution Foundation, will be intervening. We're represented by lawyer Annamaria Enenajor, who joins us today to discuss the case. Annamaria, thank you so much for joining us today. As I explained, the case uh, involves the sort of scope of police power to search, and I laid out the background facts. But is there anything else about those facts in the background here that you think is important to know?
Well, I think you've laid it out pretty clearly and correctly. The only thing I would add is that before the police entered Mr. Singer's property, they did not have what we in the legal community like to call RPG, which stands for reasonable and probable grounds, and that is the threshold that police have to meet in order to rebut the presumption of excluding the state from your property through the search powers. So they
Hmm.
didn't have reasonable and probable grounds to believe that Mr. Singer had committed an offense or that any evidence of an offense would be available on his property once they cross the threshold. So that's the only nuance that I would add.
Now, one of the things that's interesting about this case is there was this report of a vehicle matching its description. Some of the commentary around this case has suggested the police could have gotten what's called a telewarrant. Maybe you could tell us how easy it is or how hard it is to obtain a warrant in circumstances like this.
Well, it really depends on the jurisdiction that you're in, but telewarrants are designed specifically for this kind of situation where you have an individual who, or a police, excuse me, we have police who are either witnessing or seeing something in action, but they don't have sufficient grounds to enter a property or to arrest someone immediately, but they think that there could be something that would be fruitful from a search. They still have to establish reasonable probable grounds, and then they could call in an application to get a warrant, and that can be done in as little as a few 30 minutes to a few hours.
Hmm. So, in this case, maybe you could tell us a little bit about what happened at the lower level court, at the trial level, and then at the Court of Appeal.
Certainly. So at the trial level, the trial judge found that Mr. Singer's counsel had been arguing that the entry into his property, so from the moment that the police crossed the threshold from the public sidewalk onto his private driveway, that constituted a search. It is an entry into a person's private property, and therefore all the subsequent actions that the police undertook were unconstitutional. So you had to throw out all of the evidence that they found, including the evidence that they noticed on his person, which is they smelled his breath, they observed his eyes and his state of being, essentially. And the trial judge found against them on that argument. He found that the police entry onto the driveway did not amount to a search because he didn't have a reasonable expectation of privacy since they were able to view his vehicle from the road, and he was able. Then they were able to. They had an implied license, effectively, to enter his property to affect the actions that they took. Now, the Court of Appeal, on the other hand, found that was not the case. They overturned the trial judge's decision, and the Court of Appeal of Saskatchewan found that there was a breach of his right to be free from unreasonable search and seizure, and they excluded the evidence that the police uncovered in that case as a result. And because there was no evidence in the investigation, once the evidence that the police had observed was excluded, he was ultimately convicted of that offense. acquitted of that offense.
So, a lot of this case is going to turn on this notion of an implied license, and that's what we at the CCF will be intervening on. When we come back from commercial break, I want to discuss that with you. We'll be right back.